Members, as ever, the committee meeting is going to be recorded and broadcast throughout Parliament buildings and online. It's proposed that the oral evidence session with the Information Commissioner's Office on the Justice Bill will be recorded by Hansard. Are members agreed? Thank you. Also, members, just a reminder that we're obliged to declare any financial or other relevant interest that might reasonably be thought by others to influence our approach to matters under consideration. Anybody who's got an interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Does anybody have an interest they wish to declare at this stage? Could I declare that I have an immediate family member who works in the legal profession and that I'm a member of the Access to Justice APG? Deirdre and then Donna.
An immediate family member who works in the court service for 2 more days. So.
Family member works in the probation board.
Thank you. And obviously there are a number of us who are members of the APG. It's Connie, Ciara, Deirdre. Right, that's all our interests sorted out. Agenda item 3 is draft minutes. These are at pages 108 to 119 of the pack, and that's minutes of our meeting from last week, which is the 27th of February. Are members content that those minutes are a true and accurate reflection of that meeting? If you're content, then I'll sign the minutes. Agenda item 4 is matters arising. We don't have any, although I'm wondering, members, I think it would be courteous of us to write a thank you letter to the court service for the visit that we had there and the information that we were given. Are members agreed to that?
Yep.
Thank you. Agenda item 5 then is the Justice Bill oral evidence from the Information Commissioner's Office. I'd ask you to turn to pages 121 to 212 of your pack for the relevant papers. Representatives from the Information Commissioner's Office are in attendance with us today, and I would welcome Caroline Mooney, Head of Northern Irish Affairs, and Paula Hamilton, Senior Policy Officer, to the meeting. Ladies, you're very welcome. Thank you very much for taking the time to present to us today. We've all received your written paper, and we're grateful to you for coming to speak with us. We've all read your paper, and we have some general themes about the types of questions we're going to ask you. It'll be stuff around children and young people and stigmatisation, issues around the retention of biometrics, EU law enforcement, gaps that there are, some queries around reported for offences, periodic reviews. That's the type of things that we're interested in looking at with you, but obviously things of course may occur as we move through. We've all read your paper, but I appreciate you may have some introductory remarks, so I'll hand over to you and then we'll open for questions. Thank you.
Brilliant, thank you very much. Good afternoon everyone, and thanks very much for inviting us to give evidence today. Maybe start by introducing ourselves. I'm Caroline Mooney, I'm the Head of Northern Irish Affairs for the Information Commissioner's Office, and I'm joined by my colleague Paula, if you want to introduce yourself.
I'm Paula Hamilton. I'm a Senior Policy Officer in the Belfast office of the ICO as well.
Yeah, and as Paula said, we're based in the Belfast office, so we are a very small team within a much larger organisation. The ICO has offices in Edinburgh, in Cardiff, in London, and our main head office is in Wimslow in Cheshire in England. Our role basically within our team, just to set that out, is to manage and lead on stakeholder engagement and relationships across Northern Ireland, and that's across all sectors. And the Belfast office basically acts as a focus point and a point of contact for organisations based in Northern Ireland here. And that we provide advice, upstream advice, guidance, assistance to all the organisations that we regulate, engaging on national programmes and policies that these organisations may be developing. We undertake legislative consultation across the Northern Ireland departments here, and that falls under data protection regulations. So that's really our role. We're obviously a UK-wide body, and we're an independent body as well. And our main aim is to uphold information rights within the public interest and to promote openness and transparency and data privacy for individuals in line with the legislation that we regulate. We obviously regulate data protection legislation, but we also regulate the freedom of information legislation. They're probably the two most common ones that you often hear of and use, and amongst other pieces of legislation. So we do produce a lot of guidance and support to organisations so that they can get things right when they're trying to comply with data protection law. We also have a casework function, and that's primarily based in our head office. And that's where we can investigate complaints about organisations that individuals may have, and we can take action to put things right where individuals believe something's went wrong. We also have a range of corrective powers and enforcement powers and investigative powers as well as an organisation, and that can include us carrying out investigations of organisations. We can do data protection audits of organisations, we can issue warnings, reprimands, and also then the final being administrative fines as well in the form of monetary penalties. So the focus of our evidence today is primarily going to be on the biometrics aspects of Justice Bill. I suppose we wanted to start off just by saying that data protection is a really important part of the framework governing the use of biometric data. This framework oversees the processing of biometrics in a law enforcement context, and that is Part 3 of the Data Protection Act. It is necessarily a very broad and a principles-based piece of legislation, and I think it's important just to mention that at the start. And it helps to ensure transparency, to ensure accountability in the use of biometrics and biometric technology, and that can be all technology such as new ones like facial recognition technology as well. Individuals, and we worked on the data protection law, empowers individuals to give them important rights, and some of the rights that they have, which may be quite common to you, are the rights of access to copies of their personal data, and also the rights to ask for erasure of data. As I mentioned before, we do offer this complaint service and a route for individuals who may have concerns about how their data is being processed as well. As an organisation, we've deemed biometrics an important area for us at present, specifically where biometrics would intertwine with surveillance and facial recognition, and it's an area we're looking into at the minute in the ICO. We are seeing a rise in the use of biometric technology, as everyone will be well aware of, and facial recognition technology, and we're aware that tools like this may be used by police and justice sector at the minute. Our concern would be that there is the potential, if we don't know a lot more about this and a lot more about its use, as to how this maybe potentially might infringe people's rights and expose individuals and society to potential risks. So we have been working to try and improve our knowledge and understanding at the minute of this, our understanding of what the kind of future and current practices are, considering biometrics and facial recognition technologies. We're engaging with police services across the UK on this and police forces. We have been engaging with oversight bodies on this as well, and that is, for example, the Equality and Human Rights Commission across the water, the NPCC, the College of Policing, and that's to name a few of the different bodies that we are currently engaging on, and this is all quite recent work as well. So we do know that PSNI are using some forms of facial recognition technology in certain and specific circumstances. We do think it's really important that we get the approach to biometric retention right, and that means that when any new potential technologies may develop in the future, that the kind of retention regime is in place and it's established and in being implemented lawfully as well, with data protection in mind. So we do believe that getting these biometric proposals retained within the Justice Bill are crucial at the minute to get this done, and it is a first step in future-proofing any potential new biometrics that may arise in the future as well. So I suppose we had defined and we'd set out within our pack the definition of biometrics as it's laid out in the Data Protection Act in Part 3. So we did lay that out in our submission that we made, but just maybe to remind you, it is that personal data resulting from specific technical processing relating to physical, physiological or behavioural characteristics of an individual, which allows or confirms the unique identification of that individual. So that's the definition. One of the areas that we were aware of that was touched upon by different people that have contributed to evidence to this committee was that about the area of photographs and whether photographs should be considered biometric data or not. Whilst fingerprints and DNA are undoubtedly considered biometric, I don't think that can be argued. It is our general view that while someone's physical characteristics may be present in a photo, you may be able to see them in a photo, that isn't enough in its own right to make it biometric, to make that photo in particular biometric data. It's only kind of when you do something else to it, or when something else happens to that, such as some other form of a discrete processing operation on it by technical means, usually, like creating a template, a biometric template, that it actually does become biometric data, and then you're using it for the purposes solely of uniquely identifying that individual. So that's what we would say about that, and I think maybe you may have more questions later on about that. I think maybe we also wanted to mention the importance about replacing this indefinite retention that previously exists to a more nuanced framework that has been proposed within the Justice Bill. We welcome that, and we welcome any move away from indefinite retention. And we do think that it does go a long way to complying with the 5th data protection principle, and making sure that information is kept no longer than it is necessary. We would say it's up to organisations to determine what necessary is, but they should be able to do that, and to be able to justify that, and to be able to evidence that justification as to why it is necessary. And we think that's an important part of this legislation, an important part of the scrutiny that the committee should give as well. The review mechanism as well, we welcome the review mechanism that's been proposed for long-term retained material. What we would say about it, and I think we might go into more detail about this maybe later, is that data protection element or principle has 2 elements to it. It ensures that information isn't kept any longer than is necessary, but it also ensures, and that's the second fold aspect of that principle, that regular reviews are conducted and that time periods are set out for those regular reviews. And that's an aspect that whilst it's noted within the legislation, it's noted that secondary regulations may be coming in terms of this. It's something maybe that we believe should have been higher up and maybe in the primary legislation, because it's a twofold principle and you're hitting the twofold principle and addressing it at that one stage. So that was something that we wanted to raise with the committee, maybe discuss with you today. Another key part of the bill is the Biometrics Commissioner, and we would have like oversight of this biometric retention framework for Northern Ireland. We do welcome that additional oversight role that a Biometrics Commissioner would bring. And yeah, there's a few areas that maybe we would want to ask and speak about, and that's about what is meant by in the bill when it said that it is meant, or their role will be to keep under review certain new biometric technologies, I think it is, and that was an area that we want the committee to maybe look at a wee bit further, maybe if there's any additional clarity can be provided in terms of that, because we thought maybe some aspects of that could have been just a wee bit clearer within the legislation as to exactly what was meant by that. And I suppose our stance on that is because we want to ensure that there is no overlap between our role, no confusion or overlap between what we do and what we're regulated to do and what a potential future Biometrics Commissioner could do. So like, I think that's maybe where we'll leave it for some of the introduction that we wanted to make. We also wanted to mention that obviously data protection is a very important and fundamental integral part of the biometrics data. Individuals do have rights under data protection law, and we can speak more about that if there's any questions you might have on that. So yeah, I suppose maybe just to finish off, that we really do welcome the scrutiny, and we appreciate that the committee has given such scrutiny to this bill, and I think it's very important to say so, that you have done so. Yeah.
Thank you very much, Caroline. Much appreciated. Right, I'm going to go to Danny first.
Thank you, Chair. You noted in your briefing paper that the obligations to ensure transparency and right to be informed require additional measures and ensure the outcomes for children. Just from your experience, what would you like to see included in the Justice Bill that would ensure that it's adapted to meet the needs of vulnerable persons such as children?
It's an option to set it out within the Justice Bill, but if it's not written into the legislation, even if there was guidance that ran alongside that legislation that could explain that a bit further, but if there was the option to put it into the legislation, I think that would be really helpful, because from our perspective, and I think the likes of the Human Rights Commission as well, that previously gave evidence to yourselves, children are just in a more vulnerable position when it comes to matters like this. It's such sensitive personal data that's being processed, and children just generally aren't at that level of understanding that an adult would be. So organisations are sort of held to a higher standard when it comes to processing children's personal data. And again, it's heightened when it comes to the data being biometric data, because again, it's regarded as sensitive personal data under data protection law, and that just requires extra safeguards to be put in place by those organisations to make sure that the rights of the child are safeguarded, because it's written into data protection law that that right to be informed that individuals have under data protection law. Organisations need to take that one step further to ensure that the transparency information they're communicating to the individuals whose personal data is going to be processed, that when that individual is vulnerable, and it gives the example of vulnerability being a child, that it needs to be really stronger, and they need to be able to evidence this is how we've gone about this. And in the past we've seen that undertaken by organisations through the likes of focus groups with children in Northern Ireland, where they draft up like privacy information or a privacy notice that would be deemed appropriate for a child, and they actually give it to like a focus group of children and ask them, would you understand what this meant if this was presented to you? Would you understand what this means in terms of how your personal data is going to be processed? And then use that evidence to sort of tailor it to make it best fit the needs of a child. So I think that's really important for organisations to be able to demonstrate how they've built that into the processes. So I hope that answers your...
Well, it does.
Your
It
question.
sort of feeds in that risk of stigmatisation of children and young people, and particularly around the fact that the biometrics is being grouped with adults as well. Just that name concerns, and do you believe it would be a breach of their human rights, whether it's Article 8 or Article 12, that they're being breached because of this retention?
I think it's a difficult question for us to answer, and I think our perspective on that would be that the justification that needs to be provided for the retention periods that are set down in the legislation, because we know there's those various different rules in Article 63 that set out various circumstances depending on the age of the offender, but for some of those the length of retention was the same as an adult as it was for a child. And I think just across the board, across all of the different retention specifics outlined, the department need to be able to evidence this is how we've arrived at this decision, this is why we think 75 years is appropriate, this is why we think 50 years is appropriate, or whatever the case may be, because from a data protection perspective, that's what we would be asking questions about if it came our way. And I suppose that's one of the main things we want to get across today, is that there needs to be that level of scrutiny where the committee can hopefully seek that clarification from the department as to why they've arrived at this model, and particularly for children, and why they deem those specific timeframes to be necessary and proportionate and justified, and be able to evidence that as well, because that evidence part was a real new fundamental element of data protection law that was built in from 2018 onwards, when the law changed quite a lot. And the principles of data protection have always been somewhat the same since like 1998, but since 2018 that accountability principle is a new fundamental part of data protection law, and requires organisations to be able to demonstrate and evidence their compliance with those data protection principles. And we like to frame it in the terms of when you were doing a maths exam when you were at school and you showed your working out and you got marks for showing your working out on the side of the page. It's very much like that. If we can see how an organisation has arrived at a decision, we might disagree with it, but if we can see how they've arrived there and it's logical and proportionate.
We asked for that last week.
Yeah.
So we've sought that rationale.
Brilliant.
So once we get that, that'll obviously be published on the website, so you can keep it
Thank
on
you.
that. But certainly that's, yeah.
But in terms of the children, the data protection principles are the same for an adult as they are for a child.
Yeah.
So really, that examination of the necessity and proportionality must be done, and must be rigorously done for an adult and or a child. They're exactly the same. But what we would say is that, Sometimes organisations do need to take different steps when they're processing children's data, like as Paula mentioned, that transparency information, giving that information to a child in a way they're going to understand it, a simple, easy, concise, intelligible way. But also an organisation needs to take into consideration what additional risks are there for a child versus an adult, and when they're making an assessment of risks, they have to look at it under both those lenses, and that's what we would say. And a proper thorough risk assessment is part of that, working out in that evidence, so they can mitigate any of those potential risks.
Thank you, Chair.
Right, Danny, thank you, Deirdre.
Yeah, no, and thanks very much for your papers and your presentation. And I suppose that is one of the key issues that we are looking at, because the Human Rights Commission have raised this as well in their evidence around, obviously, the new retention periods. And I suppose the big thing is, it proportionate and is it necessary in terms of those competing rates around retaining the data, and then how long it's retained for. And I suppose for me, I was going to ask, have you had any engagement with the department or arm's length agencies in terms of this issue? And I was going to ask if you had a rationale to the new proposed retention periods or not. So you haven't then?
Yes, we have had engagement with the department over the proposals. So we have on certain aspects of the proposals we have, and we do have a very good working relationship with the department, and they are very open and coming to us with different pieces of legislation that they have.
Haven't given a rationale to the new retention periods then, so they haven't provided that policy kind of formation around why these new retention periods, have they provided you with that?
No, we haven't seen the site of the 75, 50, 25. We haven't seen the exact rationale, what the evidence base behind it is. The justification, we haven't seen that, but we have had an explanation as to why, in the different, why 25 is proposed by 50 and why 75 has been proposed. And they did consult with us about that. But actually, that evidence base is something that we'd be interested in, is how did you arrive at keeping something for 25 years? Why 25? What has formed the basis of 25 years as opposed to 15 or 10 or 30? What has led to that?
Would you have concern, with the proposed new periods, or is it more the rationale that led them to those figures?
Yeah, I think it's that rationale that we would be looking for. We don't have concerns as such over the period set down. I suppose we're coming from it from the perspective of that compliance with that 5th data protection principle, and that I suppose any move away from indefinitely retaining biometric material is going to go towards complying with that principle and setting out what those retention periods are. It's just that data protection law in its nature is just so principles based. It's not going to set out for every organisation how long information should be kept. It's up to each organisation to determine that necessity for that 5th principle, because it is so broad. This legislation applies to the PSNI in the same way that it does to your local corner shop. It's for those organisations to determine, right, this is what we deem necessary in terms of the personal data that we hold and how long we're going to hold it for. And it's that justification that we would be then looking at to decide, right, how have they applied this necessity and whether we agree with it or not. So I think that's something we would be very keen to work with the department on.
I suppose another area that we were concerned about, or some of us anyway, is in terms of part of this legislation is going to do regulations at a later stage, and I would agree that I feel that it would have been better to put it in the face of the bill. Human Rights Commission have said that as well from a rights perspective. And obviously we're, viewing this through that lens. So I'm just wondering if you have had any engagement with the department on that key issue, because particularly when you are looking at things like a review period, in terms of the retention of the data, the review then becomes more critical, the right to appeal, which Keir is going to touch on. But it's just to get a sense, has there been any engagement with the department on those issues, and are you satisfied with the feedback that they're giving you, or the rationale?
Yeah, we've had some early prior consultation now about the review mechanism, in particular, and kind of retention periods for that, and what the actual review mechanism will look like. But it's early days consultation, so that is still an ongoing process with them. So we would like to see more from them. We have given them feedback on and a lot of the feedback we gave was that evidence, show us you're working out, as Paula put it. Yeah, we've asked them for that and said that is obviously a fundamental part, and they need to be able to evidence that to be able to justify this. So it's a key thing when we describe that it's necessary, and they need to show it and justify that it's necessary. One part, and it's a key aspect of the fact that this is biometric data, it's classed as sensitive data or special category data, as you like to call it. And because it's sensitive, it requires that additional layer and those additional justifications. So actually, it isn't just that the information that you hold and the reasons why you retain it need to be necessary. They need to be strictly necessary. That's a higher bar of necessity, a higher threshold to reach and to get across. So that's what we were... some of the views that we give the department in terms of providing that rationale and that evidence base. So that is something that we would like to see, and we asked the department for further information on, and we said to them we would be keen to keep the engagement going in terms of that, and keep that communication going forward in terms of that.
I suppose just leading on from that then, because I know your paper sets out in terms of the data protection sets and the 6 principles.
Yeah.
Do you believe that this current legislation as it stands meets those 6 principles? Or what areas, I mean, I know you've highlighted some of them, does there need to be more work on?
I think it goes some way to meeting the principles. So we were particularly honing in on that 5th data protection principle, and like Caroline set out, there's sort of 2 elements to that. It's ensuring that data is kept no longer than necessary, and that appropriate periodic reviews are built in. And I suppose the legislation as it currently stands ticks that first requirement, but not the second requirement. Just we know that there will be periodic reviews, but we don't have any of the detail of that because it's not in the primary, which, yeah, totally agree. It would be ideal for it to be in the primary. I don't know if it's too late now for that, but it goes some way, the move away from indefinite retention goes some way to ticking that box for the 5th principle.
The concern for me is the gap of how this is managed in between the legislation passing and regulations coming forward.
Yeah.
Just my last wee query, because I know you talked again part 3 of your stuff around the EU directive and how that sits with data protection. So it's just because I know that again the Human Rights Commission raised this as well. They have set up a whole section in terms of EU directive. So it's just around anything now pertaining to that EU law or likely to come down the line that would have an impact on this current bill or our consideration around it. So is there anything else that you would like to raise as part of that area?
Yeah, the law enforcement directive, the EU law enforcement directive, we have the equivalent of that here in the UK, and that's the part 3 as we're talking about. It was implemented into UK law at the time the GDPR came in 2018, and it is known as part 3 of the Data Protection Act, effectively, and it in large part it is very similar to that EU law enforcement directive.
Anything but in terms of the Windsor framework, or that may likely to come to change some of that or to have an impact, because obviously then, you know, that would impact in terms of legislation here under the framework that was agreed. So is there anything that you're picking up that's likely to come down the line pertaining to that?
Not in relation to the Windsor framework so far as we're aware, but the main sort of legislative reform that we're working on at the minute and looking towards is the Data Use and Access Bill, which is currently making its way through the UK Parliament. It's looking to be receiving royal assent in springtime, so not too far away, but it's not going to be the same radical transformation to data protection law that we had with the GDPR. It's just going to be certain elements within the law as it currently stands are going to be tweaked slightly. I think the biggest change within that is going to be perhaps to the makeup of the ICO and our internal sort of setup and our oversight. But in terms of the actual data protection legislation, it's not going to fundamentally change, and I don't think we foresee anything in the draft text of the current bill that will impact massively on the Justice Bill or change anything, but it's a sort of the UK government's legislation, and we're sort of at their behest with that, and we'll hopefully be able to advise further on that when it is implemented and law, and we know exactly what we're working with, because the text is still draft at the minute.
Thank you.
Thank you, Maurice.
Very much, Chair. I'm thinking of the live links and the data retention, especially international data sharing, and it's a worry for me concerning the advances of AI when you can't keep a pace with it. But what concerns do you have around data sharing internationally, especially in relation to children? I'm thinking in the main about missing children and young people, abductions, etc., where sharing could be a force for good.
Yeah.
But if there's a time frame for keeping data in those circumstances and that data is deleted, then we might lose that opportunity.
That's why I think it is fundamental that when the department are setting out what these retention periods are for children, evidence such as that is built in to that rationale as to why, and it's evidence such as what are reoffending rates, the use for prevention, detection of crime. There's a whole host of factors that I wouldn't be an expert on, but it is things like that if there is with children, and for example, if there was risks of reoffending again or anything bad happening, then surely there should be evidence and a bit of a rationale as to why you're keeping something. So things like that should be built into the evidence base for children and looked at. And is there a differentiation between a child versus an adult? Would it warrant any specific particular circumstances? Should it be kept for a shorter period of time, a longer period of time? That evidence and justification should come out of extensive consultation, probably by the department, with a range of these bodies that are experts and police forces, etc., and probably overseas bodies as well, if that is a common thing.
Thanks for that. And Chair, one wee addendum on it. I'm thinking in relation to children who have gone missing and haven't been located for a period of years. Using AI, you can construct that child 6 years down the line, etc., through using imagery. And that, I feel, that sort of retention is missing from this bill. I'm not talking about the crimes and reoffending, etc. I'm thinking more of a niche market, if I could put it that way. Not a market, but a niche concern.
I knew on specific circumstance,
yes.
You think of cases like Madeleine McCann?
Well, yeah, but I don't like mentioning names.
Where they have, they've I suppose generated what she would look like at specific ages as time progressed through that case.
Absolutely. I think that the advances in AI are something that we're keeping a very close eye on. It's one of our strategic causes within the ICO is to keep an eye on that, and we have like a horizon scanning function for new and emerging technology. So that's something that we'll be continually looking at in terms of what are the risks to individuals, but also what are the benefits of these systems, because I think data protection law can sometimes be viewed as a blocker for new and emerging pieces of technology, and that's not the case at all. It's very much an enabler for it. It just enables it to be done safely, and the technologies are there and the benefits of them are amazing. You know what AI has done for healthcare and how it's being utilised even in the Northern Trust at the minute for their fracture department in Antrim A&E. The capabilities are amazing. We fully support that. It's just making sure that it's done in a safe way, and that if there's personal data involved, that's protected. But I think it's a really key point of the bill to try and make sure that it's future proofed. I think that was alluded to somewhat in the role of the biometrics commissioner that's been mentioned within the bill, and how they have a role potentially for keeping under review new and emerging technologies. Because that's somewhat part of our role as well, and there might be, the potential for overlap there, but as well as that to work together to make sure that we're aligned in the messaging we're sending out to the regulated organisations when it comes to the likes of AI, because it's one of those things, there's so much information out there, it's hard to know what the right source of truth is and where to start, but hopefully, we'll be able to work together if that does come down the line to provide that regulatory certainty together. No problem.
Does that answer your question all right?
Oh, yeah. Future-proofing part is very, very important.
Yeah.
Okay.
Ciara and then Stephen.
Okay, thank you, Caroline and Paula. Just three kind of areas I want to look at. One would be just in relation to your role And then obviously we had the Scottish Biometric Commissioner here. So have you had any conversations basically with your counterparts elsewhere in relation to biometrics, Commissioner, in terms of references and any work done on that? That would be first one. Second one, obviously we all know it's critically important that every individual should be informed exactly of how their information is going to be used, where it is, how they can access it, etc. As you mentioned, I would be interested, just your thoughts generally at this moment in time regarding here in the north and how information is gathered and captured, and whether there is effective communication even at this stage. Because I think it's critically important in moving forward and moving into DNA, etc., and biometric information, that people as individuals are fully informed, well educated of exactly how their information is being stored, how it's going to be safeguarded, security, how they can access it, etc. So I'll be interested in that. And then third one, obviously, I think it's clear, it's been constantly emphasised as critical that there's a review process built in. And then I'm conscious we have a range of retention periods, we have a range of different levels of crime. We have a range of databases that are going to access this information. There are going to be a range of levels of accessibility to different parts of the information. And then you're going to have, for instance, individuals being able to apply, like the PSNI, to apply to get information retained due to prescribed circumstance, etc. So it is a huge landscape, quite complicated. Yeah. So basically the question for me, are you familiar with systems like that? Because I'm wondering, is this going to be a computerised, automated process that can happen? Or is this a chief constable as an individual having to deal with the scale and level of databases? So that's kind of the three areas. Yeah. Thank you.
Maybe, will I start on maybe some of those last points? In terms of databases like that, as an organisation, we regulate, we're a whole economy regulator, so we regulate every sector, so we couldn't possibly see all sorts of different retention databases from all sorts of different organisations, because that would be virtually impossible. There's hundreds and hundreds of thousands of organisations that would fall under our remit. But we do have some evidence as an organisation, yes, of seeing these, and we would often go in and have an audit function to audit organisations as well, where maybe it can be consensual audits or where there's been DP compliance concerns maybe raised. So we have very good understanding about what these systems can look like, but different systems can be modern, as you know, or some can be very antiquated. And often in a lot of maybe police forces and organisations, I guess there can be maybe some older systems that are being used as well. And sometimes making changes and adaptations to different systems can be difficult to do. They can be costly sometimes, and maybe it can be hard and sometimes to add in new rules like retention rules and stuff to different databases. But it's something that these systems should be able to do. If it is in terms of deletion, it's a right to request deletion. An organisation or individuals have a right to request that. They don't always get it. It's not an absolute right, but if people request it, an organisation should have the capability to be able to delete those records and to delete data.
Should have the processes in place, essentially.
They should have those processes in place, essentially. So, in terms of I suppose the technical, what my concerns about any new systems would be, and I don't know this firsthand if they're able to do it or not, but would a police service like PSNI have the technical capability to be able to introduce all these new retention rules and flags for review periods, and would they be able to easily do that and have the capability to do that easily? It may take a wee bit of time. It might need time and resource to be able to do that to their systems. But that would be the same for any organisation to be able to do that when new legislation imposes different...
They've indicated they're going to need a new system, and they're coming up in front of us in a few weeks. So I think some of these questions...
I think to definitely ask them and an indication of is it a new system and how long would it take to make these changes. I would be inclined as well that in terms of if you're setting review periods like the 25, 50, 75 years, and then you're also maybe, if you're bringing in this review mechanism that say every so many years there's going to be a review done, that you would build that into the system at the same time, and you'd set that up. It would probably prevent double handling of the people that are setting up the retention systems. You put it in, you create rules on the systems, and they're done. then effectively. So, you know, that's what I'd be keen to do it from the outset. And that's why, that's another possible reason that from a practical element, why it would have been useful if the review mechanisms had have been built in at the same time as the retention in this primary legislation, and if that was all agreed and done and dusted, it probably would have been an easier from a practical perspective to be able to deal with that for the organisations involved. I think you did mention, you asked about, you know, what I'm paraphrasing you a bit, but what in terms of organisations here and what their data handling is generally like. Well, like a lot of the government departments in the public sector here are largely very, very good, and a lot of them engage with us.
Yeah.
We have a small local office, and they engage with us really willingly and very enthusiastically. When they're making new proposals under legislation, they do consult with us, and that is a requirement under the UK GDPR for processing done under Part 2 of the legislation, and they have the requirement to come to us if it involves personal data and any sort of personal data processing, and a lot of them do consult with us very effectively on that. So we would say that largely it is good. Organisations do know about retention periods. A lot of the time they publish their retention periods, and they're very good and open at publishing them. Their transparency information tends to be very good, and what we look at regularly, it covers all the main things. So largely across the board, organisations here are very willing to engage across data protection. They take their obligations very seriously and do comply with like anything we ask them to do, or any suggestions they make. They're always very keen and eager to comply.
I'm quite keen that we kind of stick to the parameters there
Yeah.
in front of us of the issues we have to deal with. Ciara, is that you done?
It's just in your role with
Yeah.
your current role, and then a new biometrics commissioner. Have you any thoughts on that, or work done on that, or have you looked elsewhere to your counterparts? Have they got any memorandum of understanding, or?
Yeah, that's something we would be very keen to do, is to work very closely with the Biometrics Commissioner here, as and when they're appointed, because of that potential overlap in our roles, to make sure we're sort of sending out the same messaging and that certainty to the regulated organisations. But yeah, we work quite closely and well with the similar counterparts in the rest of the UK for the Scottish Biometrics Commissioner and the Biometrics Commissioner and Surveillance Camera Commissioner as well. We work closely with them, I believe, MOUs in place.
Yes, there is.
With those commissioners. We have quite a wide remit when it comes to that cross regulatory role. We sit on, you know, the DRCF and things like that, where we are working quite a bit at the minute with other regulators who have like overlap with our role, to make sure that again we're all singing off the same hymn sheet. So yeah, we'd be very keen to continue those positive relationships here with the NI Commissioner.
Essentially at this stage, you already have a working relationship with the Scottish Biometrics Commissioner, and what you're trying to ascertain in the course of our bill is how that accountability is going to work from any commissioner here, and whether or not there's duplication or overlap with your work, and you want to make sure there's a distinction. Yes,
That's
Yes,
it.
that's
Yeah.
key.
I think it comes down to that wording within the bill at the minute about the functions of the Biometric Commissioner to keep under review certain things, and it's really what that keep under review phase really means, what that extends to. I think any additional information that the committee is able to glean on that phrase would be really helpful.
Well, I think certainly the issues that you have flagged up in your report that you think that we should consider further. I mean, it certainly would be my intention at the end of this session that I would put to the committee that we will send your paper on to the department and ask for its response in some of those areas, particularly the areas where we haven't sought clarification thus far, because some of them we've already addressed. Okay, Ciara, is that you? Right, I've got Stephen and then Justin.
Thanks, Chair. Thanks, folks, for your presentation. Just picking up on the biometric commissioner stuff, do you feel that there is conflict and overlap between both bodies, yourselves and the ICAO, and the biometric commissioners that are in place in other parts of the UK? Is that something that you foresee being an issue?
No, we welcome any additional oversight, any kind of clarity and more regulatory certainty and oversight that can be given to individuals and organisations. We would welcome that. What we have found is that we don't see the potential for overlap, like in terms of some of the proposals, but just some of the clarity maybe around keep under review, because it is quite a vague term. We wouldn't want that to be
Yeah.
leading into work that we're doing, because obviously duplication wouldn't be good for anyone. If we were writing a report about new biometric technologies or doing pieces of work into that, and they were doing something very similar, it wouldn't be a good use of anybody's resources. So, but an MOU, things like getting agreements and an MOU in place is something that we would be very willing to do. And
So there's a formal MOU in place
Yeah.
with the Scottish Commissioners.
there is, yes, and we publish that. That's published on our website.
And you would be looking to replicate that here.
Yes, there would be
yeah.
the same approach would need to
Yeah.
be taken.
So
Yeah.
just the other point in terms of the PSNI stuff, and we've seen in recent times, the importance of data and so on, and the sensitivities around it all. I suppose link it back to the IT issue, and you put that in your paper, that both the DOJ and PSNI obviously will have to upgrade their systems substantially. Are you confident that can be done? And is there any lessons that we can learn around that can link in with the bill?
Well, we can't speak about it from a budgetary perspective,
Yeah,
obviously,
but
because
that's gonna be a challenge
in terms of systems, if that was found that they did need new systems, if the old one wasn't able to do that obviously they would have to look in that. It would be, I'm sure, a huge system, and it would be a big undertaking for any organisation to update a system such as that.
Are you involved in that process in terms of systems as an ICO?
No,
you're not.
no. If any new or any organisation that would be procuring a new system, we wouldn't be involved. But we sometimes would be involved in terms of providing data protection advice, that upstream kind of advice to an organisation about the potential risks and compliance issues and pitfalls that there might be with updating such a system. Doing something like that on such a huge scale can be inherently risky, and as you know, migrating records from one system to another can often be very difficult and very problematic, and does pose risks because of such the large volumes of highly sensitive data that is saved on such systems. So we probably would be involved in providing that kind of upstream advice to organisations like that. They're doing things on a huge scale like that. We've been involved in other sectors providing that type of advice in a similar way.
Yeah.
Yeah.
Okay, thank you. Thanks,
All
Chair.
right, Stephen, thank you. Justin?
Thank you, Chair. Thank you, Caroline. Thank you, Paula. Very informative evidence session. Just a quick one on the retention of legacy biometric material and data. Where does that stand in relation to the Justice Bill?
Sorry, just repeat that, please, Justin.
The retention of legacy biometric material and data, where does that sit in relation to the budget bill? Sorry, the budget bill, not the Justice Bill. Forgive me.
I don't think from my reading that
No, I think
I don't
part
think
of-
it's part of the bill. I don't think it's specifically covered in this bill.
I think part of the issue, Justin, was it was covered in the Legacy Act that went through
Yeah.
Parliament, that whatever the legacy stuff would be retained for the sole use of the ICRIR, and at the point at which the ICRIR concluded its work, then that stuff would be destroyed, which I would think is a massive concern. But that's my understanding as to what's going on with legacy biometrics. Isn't that right?
That would be my understanding.
Yeah.
Separate mechanism.
So I think at this stage we're waiting to see whether or not, since the government is doing a review of legacy stuff, I'm not clear whether there'll be any changes to that yet. We're not clear on that front just yet, I think. Some stuff they've pointed out they're looking at, but we haven't heard anything definitive on that thus far.
It would be an interesting area to keep across, so, in
Yes.
case
Yeah.
there
Important.
is any developments.
Very important for victims.
Yeah.
Go ahead, Justin.
That's all. Thanks, Chair.
All you
Thanks,
had.
folks.
Thank you. Doug?
Yeah, thanks, Chair, and thanks for the evidence. Can I just ask, because you were very decisive in saying that photos are not biometrics. I wish our Department of Justice was as sure-footed as that. Yet the Scottish Biometrics Commissioner was absolutely equally decisive to say they believe they are biometrics. Well, why such a difference?
Yeah, well, what we said, maybe just to clarify this to make sure I'm clear enough, that a photo per se, a photo in its own right, isn't biometric data. It's when something is done, or like a technical process is done to that photo and it's used for the purpose of uniquely identifying somebody. That's what makes it biometric. So a photo like that you would have on your HR file, for example, a photo stuck to the front of your HR file wouldn't be biometric. But if you created a template of my photo on my HR file, you know, did the necessary technical things you need to create a template and put that into like a facial matching system, for example, to match me with other workers in the organisation or match me against some other sort of a database, you would be using that and that template to uniquely identify me. So in that sense, that would make it biometric data, and our guidance and the description and the definition within the Data Protection Act is very clear on that. We did, I think in our paper, in our submission to you, we did mention that, you know, is the department, is PSNI routinely, and that's the question I'd be asking, are they routinely using photos, or are they routinely using like templates or biometric templates? Are they using photographs for the purpose of uniquely identifying someone? And if they are routinely doing that, then yes, it is something that because you did ask, you know, should there be, and people have asked, should there be consideration of that? If it's routinely being done, and for the purpose, and as long as it is, and it meets that definition for the purpose of uniquely identifying someone, then it could be, yes, classed as biometric. It would render those photographs biometric when they're being used in that way.
And therefore, the base material, the raw material, which is the photograph, in effect, even before it's treated, in many ways, could then lead to it being a biometric. It's nearly the start process, and therefore, though, should it then, because it's a raw. Now, let me give you an example. So, if you take a picture on an iPhone Live, then the picture has a movement to it. If it's done on iPhone Live, that must automatically then be a biometric photograph. Is that right?
No, well, it's not then used for the purpose of uniquely identifying someone. So if you were plugging that into some police database that could match against something, that's what makes it biometric, when it's used for the purpose of uniquely identifying somebody. That template, if it was a template created from that, is used for the purpose of identifying.
I think what we need to understand from the PSNI whenever they're in is the point at which they just keep photos for the sake of having photos, or the point at which they use photos or put photos through systems. And we need to understand in their processes the distinction between the two, and I suppose the ratios between what's kept as just a photo and what photographs are used for further purposes. I think that's a question
and
for them.
Yeah, and I kind of get that, Chair, and I'm just trying to really tease this out, because if that's a fact, then actually you can retain photographs for as many years as you want, as long as you don't treat the photograph. But that means you could treat the photograph in 60 years' time. You know, so you're actually holding on to the base material. I have no issue with that, by the way, but you're holding on to the base material for as long as you want.
Well,
and
really,
it's not until you actually treat that base material does it become the biometric.
Yeah, the base material, like anything else, like any file you hold in, would be subject to a retention schedule as well, and you need to lay that out. So that's it. And you can only keep that base material, if it's a photo or a file or whatever it is, you can only keep it for as long as is strictly necessary and proportionate, in the same way, in exactly the same way. So you would have to have that set out. So they should have policies and retention periods on photos. Regardless,
and that's where, sorry, Chair, and that's where
it
falls to what Justin was asking about in legacy, because if they're talking about they want to retain photo stuff and information from 50 years ago in regards to that, that's kind of the same principle. But I think you've answered it. I think I understand exactly what you're saying. I just think there's a little bit more to it than maybe I fully understand. But listen, thank you very much. Thank you, Chair.
Thank you, Doug. And actually, your questions are a reasonable segue into mine, because I've got some questions around this too, and about photographs and whether or not we understand at present the PSNI is using a service instruction around photographs. To your mind, is that sufficient?
I think that service instruction is for the purpose of the deletion, and when people request deletion of their custody photographs, for example.
Yes, is that enough, or should there be something in legislation rather than just a service instruction?
Well, that service instruction is setting out like the process that the police should follow in terms of how that material is deleted and how someone should request a deletion of it. So it's appropriate that they have a service instruction or a policy in place which details how to do that. So yes, that is correct. In terms of like custody photographs and like any material, as I mentioned, any organisation should have a retention period and a retention schedule set out for the material that they hold. And that's a requirement under the Data Protection Act. And if it's, for example, your HR files in your organisation, your custody photographs, your files on people, they'll all have different limits and different timeframes, and that should all be set out. But a service instruction does go some way, I think, and I think it's possibly, if my understanding is correct, was a bit of a bridging mechanism or an interim position until this legislation should be pushed forward. Yeah.
Yes, well, I think we've sought sight of the service instruction to understand what's in there, but as a result of your paper and just on some post-legislative scrutiny that we're doing, I think we're going to need to, your paper has highlighted some questions that we need to pursue further with the department, but also with the PSNI. And certainly I would want to have understanding, and I suppose if folks could take a note of this for what we're going to ask of the department. I think there's certainly issues around what the PSNI shares on national databases and the time frames there. I think we need to understand how long it's going to take the PSNI to develop an IT system, and when the department intends to commence this part of the bill, because the problem with it is the department can commence all it likes, but if the PSNI is not ready, then it's pointless, and that's actually how it fell down the last time. Well, it's partly why some of this fell down the last time, and also I think we need to do some work between the department and the PSNI over the costings around any such system. The other thing I think we need to check is that we didn't check with the Scottish Biometrics Commissioner was whether or not his role is full-time, because we don't have any concept in this bill as to whether or not this is viewed as a full-time role for a commissioner. Go ahead,
Not on the
Deirdre.
databases, the international databases as well, because they touched on that in
So there's
terms of
national
European.
databases, international databases.
But also, is there any cooperation north-south also, and exchange of information, just so that we're asking the question?
Can I make a wee point about the databases and those national and international databases? If this legislation should go ahead and you set specific retention periods, they'll most likely be different in Northern Ireland than they are elsewhere, who maybe haven't got round to legislation such as this yet. So, they'll be imposing different retention periods based on what jurisdiction you're in, and maybe England will be different than Northern Ireland and Scotland. And if your detail, your DNA or your biometrics, for example, are held on both a local database here and one of the matching databases across the water, if they're held for different periods of time and the material needs to be deleted, will there be the capability to delete it of both the Northern Ireland database and the UK database as well? Because like in data protection law, when somebody requests erasure or when something should be deleted, you should be deleting it, and that means deleting it of all applicable sources, databases, for example. So that's something maybe to ask,
That's
how
part-
logistically
yes.
that could be done as well. Just
that we need to check, particularly that if the retention periods are different, and we can understand why they would be, then which jurisdiction will take precedence. But I do understand that there are conversations ongoing with the Home Office around some of these issues, but these are issues we have to take up with the department. So ladies, thank you very much. You've given us plenty of food for thought. We appreciate your time and your evidence. I presume the committees agree that issues that are raised within this paper we can send on to the department and the PSNI as necessary and follow up with some of that. Does anybody have anything further before the ladies leave us? No?
We'd be more than happy if you do think of anything or anything additional. We'd be more than happy to help you with anything or provide additional clarity on anything.
No, that's great. And as we get information, it may well be that you've got more to say. So please keep an eye on the website. We'll publish everything that we have, and we may have further questions as we get information too.
Yes,
So
thank you.
Thank you very much. Thank you. Appreciate it. Thank you. All right, members, then agenda item 6 is the Justice Bill written papers. At 6.1, you'll see there's correspondence in from the Taxing Master. I'd ask you to turn to page 214 of your pack for that, please. At our meeting on the 30th of January, we agreed to invite the taxing master to give oral evidence on clause 28, which is the restriction on ordering taxation of legal aid costs of the Justice Bill. You'll see from that the taxing master has responded saying that any approaches to the judiciary should be sent through the Lady Chief Justice's office, and that if the committee would like further information on clause 28, it should liaise with the Lady Chief Justice's office. Now, in fairness to our officials, the address that Cathy wrote to was the address she was told to write to. But we've got another direction now to go through the LCJ's office. So before we do that, are there any specific issues that members want to request from the taxing master, or are we content to allow the officials to go and bring back a couple of subject issues that we've raised in the course of evidence, and then we'll take it from there?
Agree with that, yeah.
I mean, I think some of the stuff we've raised is pretty clear. It's around expertise in the system, and the case by case basis stuff. What is the role of the taxing master currently? How is it determined? How much will be taken off a bill? How does he determine what's value for money? All of those kinds of questions. If we have some understanding of what's in existence, and then we can look at the pros and cons as to what's proposed in the bill. Yes. So are we content for officials to go off, do a bit of digging on things we've raised thus far, and then we can pull something together?
Yep, agree with that approach.
Thank you. Item 6.2 is correspondence from the Attorney General from Northern Ireland. So we'd agreed a list of stakeholders that the call for evidence should be issued to, and this included the Attorney General for Northern Ireland. So the AG has responded stating that she doesn't propose to make a written submission on the bill. Are you content to note that?
Noted.
Thank you. Then the Youth Assembly. So the Youth Assembly has been considering the Justice Bill and hopes to produce a report to provide to the committee. They've also requested an opportunity to provide oral evidence to the committee on the bill in April. I would flag up to committee members that the Youth Assembly will be one route to engage with young people, but others will follow. This will not be the only means of us engaging with young people on this. Are you content to receive oral evidence from the Youth Assembly?
Yeah, agreed.
Thank you. We've dealt with the informal event. Agenda item 7 then is post-legislative scrutiny, and I'd ask you to turn to page 217 of your pack for that. And there's quite a few bits in here. So let's just get the context then. So following briefings on the 10th of October 2024 and the 5th of December same year, the committee agreed a number of questions to be sent to the department in relation to post-legislative scrutiny of 9 Justice Acts from the 2011 to 2016 mandate, and then the 2017 to the 2022 mandate. The department has now responded to the committee's agreed list of questions on each act, and those responses are included in your pack. So I need to know whether you're content with the responses or if further information is required in respect of any specific acts. But also I think we need to consider how we're going to handle these. There are 9 issues in here. My view is that we should not be getting down into the weeds of this today. But rather the thing to do may be, you eat an elephant in bite-sized chunks. And maybe we need, for the next number of weeks or months, take a couple of them, look at them in greater detail, see where we are, if we need further information or not, because it strikes me that for some of this work it's not just about hearing from the department. For example, there's reference in there to Lord Morrow's bill. I think we should be hearing from Lord Morrow about what he thinks about how effective his bill was or otherwise, and any barriers that there may have been, issues like that. And certainly there's stuff in here that pertains to this bill, particularly around the IT systems that came out in one of Johnny's papers there, that part of this fell down because there weren't any IT systems around the biometrics and the retention of data. So there's stuff in there that is pertinent to what we're doing right now. Anybody have any thoughts on this? Deirdre?
Yeah, no, I would agree, Chair, because there is a lot in it, and our previous sessions were very useful, even in terms of the current legislation that we're scrutinising. So I think if there's a way over the next, without rushing into it all and trying to do it in the next couple of weeks, if we can sequence it in a way that, anything that may be of interest or use in terms of the Justice Bill, start to look at that as we're looking at those areas. And then there may be parts where, we're going to get presentations or updates from the department on certain aspects of previous legislation.
Some things have been superseded.
Yeah, so could we align it to that and, take a wee bit of time at each committee then, so just in more manageable chunks, as you say, and if there's a need to invite other people in to give evidence on those, then I think it would be good.
Yeah.
And try and look at that over the next year or so. Yep.
I think that it's a bit more manageable. Just so
100%.
we prioritise in accordance with things that are, still on the go, pertinent to the bill, and anything else as we take them through that arises. I don't want us to gloss over this. I think there may be times when we need a bit more from the department or others. There may be times when we don't. We've got all we need. Everything's fine. So are members content with that approach? Yeah. Is there anything that you want to raise about what you've seen in the papers thus far?
Probably a couple that stood out for me, and obviously particularly the ombudsman, the prisoner ombudsman, particularly given the ongoing concerns that we did have. I suppose just in totality, and it's about the pressures that is on the prison service at the minute and the number of people in remand and resources and stuff like that. So that's one, because I assumed it wasn't statutory line until we realised when we done this piece of work that it hasn't been progressed. And then the likes of, there was no explanation just even in regards to the fine collection guidance section, nothing. We don't know why that hasn't move forward. No explanation as to delay. So there are two things that kind of jumped out regarding all of them, but I suppose I'm happy to reflect and then maybe we collectively prioritise mine, even if it's one a week and looking at it and and start.
Or one every few weeks, but certainly with regard to the prisoner ombudsman, Ciara, we had agreed last week.
Get them in.
Yes, but I think we're allowing him a bit of time to get in. Yes, to get in there, establish what work he needs to do, take a few things forward, just give him a bit of breathing space. I mean, he only started in November, so just allow him a bit of breathing space, and then bring him in, I suppose, when we're a wee bit further down the road and he's got things to report and made a bit of progress. Yes, I'd be concerned around the issues that are particularly pertinent to the bill, and the IT system is certainly one of them. I think there's a lot of stuff in there we can do. Johnny, is there anything else you want to add about this?
No, I just wanted, just sort of on a procedural technical point, a number of the letters referred to the previous committee clerk wrote to the department on the 13th of December. The clerk asked firstly why X, Y and Z. And it's just anyone reading this without the context of the original letters would be forgiven for thinking that it was the previous committee clerk who was seeking this information of her own volition rather than at the behest of the committee. So I just wanted to state each of the letters do state the committee agreed to ask the following questions and then listed the question. It's probably just a matter of wording, but I just wanted to clarify that the committee did indeed agree the questions. It wasn't the committee clerk going off herself and doing it. So, yeah.
No, and I think certainly would want to commend you and the team for the work that you've done in this sphere. It's been really useful, and I think it'll really help us going forward, because there's no point in passing legislation if stuff isn't implemented. And sometimes there can be reasons why, and sometimes why not. But I think it's useful for all committees to take it on board, and certainly this work has been raised at the chairperson's liaison group about its good practice, and all committees should be doing it. So good news for the Committee for Justice. So well done, team, on that. Right, everybody happy enough then?
Yep.
All right, thank you. Let me just check if there's anything else I need to raise with you around that. Yeah, once we get some of this stuff, we'll determine whether or not we need things in writing or whether we want oral evidence. We'll just see how it goes and the gravity of the issue in front of us and the depth that we choose to go into. All right, agenda item 8 is the Domestic Abuse and Civil Proceedings Act, Northern Ireland 2021's report on operation, and it's a written paper from the department. Could you turn to page 292, please? There's a lot in this pack relating to domestic abuse, and before we get into it, I think it strikes me that because of the nature of the things that are being brought to us at the minute, it strikes me that we require to do more work in this space. Now that's not easy, bearing in mind the work programme that we have, but we have this report, we have reference to domestic homicide reviews, there are a number of other issues, we have the complaints from members of the public, and certainly on my own caseload, and I raised it in the chamber last week, I am slightly worried that we're not able, or we're not demonstrating that we're able to do two things at once. So there's a distinction to my mind between the Violence Against Women and Girls strategy, which sits under TEO, into which the DOJ feeds, but the domestic abuse strategy that sits with our department. And in the focus on women and girls, which is merited, and this is not to detract from that, but to my mind, we need to be able to do two things at once. We need to be able to walk and chew chewing gum. And in the domestic abuse space, what I am seeing is that while there's still a raft of work to be done around female victims, I am concerned that men and boys are falling behind, and they amount to almost a third of the victims in this space. So whilst the priority is women and girls because of the strategy there, then my casework is indicating to me that there's insufficient professional curiosity from the agencies and bodies around what's going on with men. And actually, when you look at some of those cases, if the roles were reversed, that wouldn't happen. So I just want to make sure that in the domestic abuse space, we as a committee are actively seeking to ensure that all that's being done, all that can be done is being done, all that should be done is being done, or at least is on the horizon. And I mean, I was heartened by the Minister's response to the question last week, but I just don't want victims of domestic abuse from whichever, whether they're women and girls or whether they're boys and men, to fall off, because they each have their own barriers as to why they don't come forward. So all of these things, the homicide reviews, these reports all feed in together, and I would like us to maybe take some time at some stage to dig into this in a bit more depth. Are members agreed with that?
Yeah.
Yeah.
Yes, because it is pretty extensive, and obviously it even, I mean, part of it, the domestic abuse proceedings feed into the post-legislative scrutiny.
Yep.
And I think, I mean, I would even be keen, we'd be keen to look at a briefing on it in terms of, because I found last week's on the tag and stuff very useful, you know, and it was, we probably should have done that before, but I think on this issue as well, because it is so relevant, it's impacting right across all of our constituencies. To kind of take a more specific, to put time in our forward work programme, to get the officials in to do the wee bit of legislative scrutiny, whatever way we kind of programme that in, and to maybe talk to some stakeholders on the issue as well, I think would be good.
Well, what particularly struck me, and we'll come to it as we get to the correspondence, but what particularly struck me was the fact that even whenever we flagged up the complaints that we had received from members of the public to this committee, when we flagged that up, then the department came back to say, actually, we're looking into this. And Cathy and I had a conversation about this. So the fact that the department's taken it on board indicates to me, right, there's a lot going on in this space, and there's a lot in our pack this week, and I would like us to take a bit of a look. Conor, you want to come in on this?
Yeah, thank you, Chair. I absolutely agree. I'd love for us to focus a lot more on domestic and sexual abuse. It's something that I'm really passionate about, and I think the Minister's answer, as you referenced last week in the Chamber, was helpful, and obviously the domestic and sexual abuse strategy, which falls under the Department of Justice in this committee, you know, it's about all victims, so I think that is very useful, and there's definitely some organisations I'd love to get in front of committee to hear their perspective on that. So just to say totally support them, would be really keen for us to take some of that work forward.
That's good. Ciara?
I'd just like to mention as well, and I would agree, it's critically important, and it's about everyone,
Yes.
male or female, but also what's critically important is the impact on children as well. So I would very much be keen that we bring it forward. I think it needs a lot of detailed work, because I was conscious and just in our packs and what we had to read through, and basically the Marcella report, the complaint, the responses back from there, it's just building a case of what I see on the ground and caseloads that I've been working with, but not only caseloads in the present day, but also caseloads over the last 10 or 15 years when you're working within a family support hub on the ground. So I would be very keen, and I know it's a large issue, because and a lot of it's to do with resource issue and collaborative working and stuff like that, but I think some good work is happening. But I think I would really like to drill in on kind of key issues that seem to be flagged up across these reports, and what is happening and how we can assist and bring that forward to improve.
Yes, I absolutely concur. I think the problem for us is always going to be time, but I think we can make it work. and it's a serious issue that is no respecter of class or creed or gender, and there's a lot going on in this space and we need to look at it. So that, members, thanks very much. I mean, we'll obviously have more comments to make as we work through the agenda, but at least I think we've got a strategic direction. Right, let's look at this then. Agenda item 8 then, the Domestic Abuse and Civil Proceedings Act, report and operation. So the Department is required to publish a report under section 34 of the Domestic Abuse and Civil Proceedings Act, Northern Ireland 2021. Do members have any comments on the report, or do you require any further information specifically to the report at this stage? Anything further on the report?
Yep.
No, I mean, statistics are fairly disturbing on it, but we'll note those for now. Bear in mind, we're going to get a briefing on Deirdre.
I know, I was going to say, yeah, because it is a big report and it's concerning. Some of the figures, as Ciara said, are even around young people and the amount of young people that are witness to this as well as victims. So I think as part of the work that we've just agreed, to kind of refer back to this report as well would be useful.
Thank you. So all content to note, yes, for
Yep.
now. All right. Agenda item 9 is court-ordered community sentences for children and proposed consultation. There's a DOJ written paper at page 349 of your pack. You'll see from that the department intends to hold a public consultation on a new single court-ordered community sentence for children to replace the existing sentencing framework. Are members content to note the papers and consider the matter further when the results of the consultation and the way forward are available, or do you require any further information or clarification at this stage? Danny?
Yeah, it's just reading through it. I have a slight concern around this, the task force and then the stakeholders. I would like to know if they had engagement with the likes of the Children's Law Centre, Children's Commissioner, because there's reference there to the community sector, community value sector, but it doesn't say who. And I know it's going to go into public consultation, but we all know how stretched the community value sector also will be, and limited staff, and a lot of work gets fallen on top of them. So I'm just making sure that people are getting a good chance to feed into this, particularly around our vulnerable, like our children with special educational needs and all of that. So I would like to know if that did reach out and work alongside the Children's Law Centre and the likes of Children's Commissioner, and if they haven't, why haven't they?
Well, I think we can check that. The other thing is, I'm not clear. It seems to me a fairly common sense approach to move into one order rather than have a whole dose of these. But there's reference to some of this in the bill, and I'm not sure if it's the same thing. So could we maybe check also, first of all, are members content with that we raised Danny's point with the department?
Yeah.
For more clarity. Yeah.
And then can we check with the department how this relates to or interacts with the proposals in the bill that we have in front of us, which again talk about this move towards one single order? Yeah?
Agreed.
Thank you. Agenda item 10 is correspondence. So there's correspondence memo and 15 items of correspondence, and starts at page 397 of the pack. I'm going to draw your attention, as I always do, to a number of the items, and then I'll open the floor for folks to raise or comment on any other issues in which they have a particular interest. First of all, can I ask you to look at items 10.4, 10.5 and 10.6. That's 3 items of correspondence starting at page 410. At our meeting on the 6th of February, we considered a copy of a complaint addressed to the Judicial Ombudsman from 2 individuals regarding the handling of domestic abuse cases within the judicial system, particularly within family court settings. And we agreed to forward that correspondence to the DOJ, NIPSO and the Lady Chief Justice for their views, and responses have come in from all 3. You'll see that the Department has issued a holding response, and then we'll see, first of all, can I ask you to note the items of correspondence? And obviously we'll follow up then once we get the substantive response from the department. But also, the Lady Chief Justice has advised that she would welcome the opportunity for a more in-depth, informal discussion with senior family judiciary in relation to the family court in the Royal Courts of Justice. I think that'll be really useful. Are members content that we move to arrange that, an informal meeting? I suppose the only thing is, are you wanting to do this outside of committee time? Maybe it's a Tuesday lunchtime kind of thing, is it?
Later, yeah.
Happening up here Tuesday.
Yeah,
Tuesday lunchtime type thing? Right. I suppose if that's the case, the aim would be to have the Lady Chief Justice and whoever she's bringing with her, whatever judges, to hear. Could I also ask, could I seek your agreement that we would send the responses we have received on to those who wrote to us on the issue? And also if we can seek their approval, you'll note from the Lady Chief Justice's response that she can't check whether or not a response was issued because it was anonymised from when we sent it to her. So in order for her to do that, she would need to know. So if we can check with the person who wrote us that they're content for their details to be forwarded on to LCJ so that she can check.
Yep.
Is that all right?
Yep.
That's lovely. I just think if people write to us, there's an onus on us to respond. Thank you. Item 10.7 is correspondence from the department at page 424.
Sorry, Joanne, could
Yes,
I just, on that similar correspondence to 10.6, could I just raise another 2 areas? Obviously, I welcome the establishment of that judicial family working group to explore, obviously, the current family court system. She did mention which I wasn't aware of, a judicial studies board, who are the ones that keep the subject area under review and consideration. That's what their job is. So I'm wondering, could we request further information on this judicial studies board, how it operates, who is it, and potentially invite them along if we are having them. They may be part of this senior judiciary in relation to the family court. I'm not too sure, maybe they're a separate body altogether, but I would be very keen to find out, because obviously they're the ones that kind of oversee the cases and any ongoing review of cases in relation to this.
Yeah. Well, let's seek that information. I don't want to necessarily tie them into that meeting with the Lady Chief Justice because this was at her behest, so I don't want to be. But let's see where we are with it and then how we want to follow up.
Yep.
Yeah, once we've got the basics. Our members agreed? Connie, you want to come in?
Yeah, thank you, Chair. I think just on the same item of correspondence, 10.6, I would really welcome a meeting with the committee with the Lady Chief Justice. I think when we discussed earlier, domestic abuse, family courts, and in particular child contact, when there has been domestic abuse, is an issue that's been raised with me increasingly as an MLA, and it's something I'm really struggling to get answers on. I think there's not a lot of the ability to scrutinise the work of family courts, so I think a meeting with the Lady Chief Justice would be useful for the committee, and I look forward to that, and I agree with the points Ciara has made as well. So as much information we can get on this, I think would be helpful, and I think it would tie in nicely with any work we're doing on domestic and sexual abuse.
Yep, that's fair enough. So we're going to go for we're aiming for a Tuesday at lunchtime, round about there, yeah?
Yeah.
Okay.
Well, Joanne, could we possibly ask or write to the Department of Health to get information on the current contact centres, child contact centres? Because I know a lot of them are kind of private run, and it's obviously part of the system. And I'd be really keen to be more informed and educated around the use and management of the contact centres, where there is an agreement between the judiciary and the Department of Health in relation to child contacts when parents are contacting. But there has been a proliferation of these child contact centres now. Majority of them are private run, and I'm just not clear of what power they have in relation, where they sit in relation to judiciary and the court orders and the decision making in relation to the use of parents, carers when they're meeting their children. It's a grey area for me, and I would like to have more information on it if possible as well.
Yeah, maybe correspondence that needs to go to both the DOJ and the DOH.
Yeah.
That one.
Okay.
Members agreed? Yeah, thank you. 10.7 then is correspondence from the DOJ at page 424, which relates to the publication of an executive summary report on a review that was carried out by a domestic homicide review panel. The panel has made 10 recommendations, and the DOJ has said that considerable progress is underway towards the implementation of the recommendations made. I'm seeking your agreement to request an update on the implementation of the recommendations, but also think that there's an issue around, like, there's recommendations here for everybody, and there's a raft of them. And now we're about to engage in the Cresswell review, so we have a lot of stuff on the go at the minute in this space, as we discussed. But it's trying to say, okay, who's actually going to take the lead in this? Because there's all recommendations for various partners, but then things just fall by the wayside. So we need to understand, I mean, part of the fundamental problems here have been lack of communication and information sharing. And I think that's going to equally apply to the recommendations. How do we ensure that these recommendations are followed through? Because we've seen from our own experience with Sagini that there's recommendations made and then they go back a couple of years later and say, well, where are we with this recommendation that you accepted? But very little progress has been made. Now, some of that boils down to resources, of course, but I think we need to have some understanding, and maybe this is work that we can do in conjunction with, or we can flag it up also to the Committee for Health. Yeah, our members agreed with that, just to find out kind of how this is all, because if something doesn't change, nothing's going to change. You know?
And likewise as well, and it's something similar to the Department of Health, where we're constantly advocating for care pathways. So there's a clear pathway of communication, not only for the individual or the patient, but also for the team, and what your expectations are. And as you say, there's a lot of agencies involved. There's huge recommendations. Every report you go along, there's huge recommendations, and there's a lot of organisations probably doing great work. But how do you decide that as an individual if you're faced in those circumstances? What's the care pathway and what should you expect? What's the standard and quality you should expect? That's what we should be working towards.
I think there are a number of things kind of coming down the track, and certainly this will feed into, I think, the Cresswell review. I think we'll be in a better position once that's finished. But for now, let's get an update on that. Let's keep a note of the questions that we'll want. And we can ask the initial question as to, okay, what does coordination look like in this space, and how are you going to make sure that everybody's coordinating on the recommendations thus far? Is that fair enough at this stage? Yeah? All right, thank you. Next item then is 10.8, which is corresponds from the DOJ, page 428, and that's a response to the committee's request for the Minister's response to the independent review of the Policing Board. Are you content to note this item and consider further when we've got more information? Agreed?
Agreed.
Thank you. 10.13 is corresponds at page 550 of the pack. You'll see it's been forwarded by Open Government Network Northern Ireland from the Committee for Finance. The Open Government Network found that 2 departments did not proactively publish freedom of information or environmental information regulations, and one of those was the Department of Justice. The department subsequently did provide the information to the Open Government Network. So I'm asking your agreement to ask the department to clarify if it intends to proactively publish freedom of information and EIR statistics in future, or if there was any reason why they did not or could not. Are members content?
Agreed.
Thank you. 10.14 is correspondence from the DAERA committee. That's page 550 of your pack. It's a request for our views on the agriculture bill, which was introduced on the 25th of November. We haven't, the committee hasn't taken evidence on the agriculture bill, and we haven't formed a view. But I spoke to the clerk, and I don't think there's anything in this bill that pertains to sentencing or fines or anything that's in the judicial space, not into the justice system space. So can I have your agreement that we submit a nil response, or does anybody have anything they do want to submit on this or raise on this? Content with a nil response?
Yep.
There's nothing in this that pertains to us, I think. So, agenda item 11 is the forward work programme. Oh, sorry, before I do that, are you content to note or action the other items of correspondence as set out in the memo, or do you have any comments to make on anything else, Deirdre?
Yeah, it was just on the 10.2, Chair, in terms of the paramilitarism programme, and it was just to really say, I mean, it's not to do any follow at this point, but in terms of just highlighting some of the concerns around the billboard campaigns. So I don't think anybody's naive to think that these groups don't operate, and they don't operate across the community. But I am concerned around some of the stigmatisation, particularly of working class communities, and some of the characterisations in terms of geographical areas. Some of the communities that people live in, those communities don't see some of those characterisations. So it was just a note that is just a concern that I've been picking up with regards to that programme, and if they are going to do it going forward, to make sure they're aware and that engagement with communities is key.
Well, I heard that raised in the chamber. Actually, it was raised with DFM. I suppose the one thing that I would say is that there are a number of us who sit on the political advisory committee of that, and all parties are there.
I know.
And there were some billboards that we felt, no, that was inappropriate and didn't necessarily reflect, and action was taken on that. But these particular billboards were approved by every party present. And we did feedback and there were concerns raised, but those billboards that were issued. So I don't think there was an intent there to stigmatise, but the issue with it is it's by and large it's working class communities where a whole raft of this stuff, you know, where these parasites are feeding off the back of their own communities in these areas. So that's where it came from, and all of these billboards and all of these campaigns are put through that political advisory group for feedback before anything is taken forward, you know. So I see where you're coming from, Deirdre, but there was
concerns.
feedback.
All I'm saying is concerns have been raised from the community, and I think it's just important that those concerns are reflected in any campaign going forward. So I suppose that it was just to say that.
That's fair enough. Justin?
Thanks, Chair. On the subject of billboards, where political parties have erected billboards illegally on DFI property, where does this committee stand? And can we write to Justice Miller to seek her position on where the legalities of that are?
It's planning, I think. That's infrastructure, is it not?
It's infrastructure.
Yeah, just
Justin,
on the matter of billboards, we're talking about billboards and how that can stigmatise communities potentially. And where political parties who've spoken here today actually erect billboards illegally, where does that stand from a judicial perspective?
Not illegal. It falls under a different department. So it would be for DFI.
Justin, when you're talking about people erecting billboards illegally,
I'm talking about political parties erecting billboards illegally.
I think that's a planning issue. I mean, we can write and check with the department, but I think that's a planning issue ultimately.
Can we seek an opinion from the Minister on that, please?
Yes, certainly. Are members agreed?
Yeah.
Yep, I'm happy.
Yeah, we'll write and check.
Apologies, Chair. I couldn't get my hand up on Zoom there.
Apologies, yeah.
Look, before we write, I just want some clarification about just examples, Justin, genuinely. Is it on street furniture? Is it
It's a
on
billboard.
property,
It's a
council
billboard.
property?
It's a billboard erected illegally in my constituency, which I've written to the Infrastructure Minister on before, which she's aware of, and it's a legally erected billboard. So we're on the subject matter of billboards. I just thought it was a pertinent point to raise when political parties are actually erecting billboards illegally on DFI property, and very prominently in a very high visible position at a very highly trafficked junction.
Okay. Look, no problem getting the minister's opinion on that. I just wasn't aware of specific examples if it's in your constituency, Justin. But look, just wanted a bit more clarity on that before we agreed to send anything.
I can give the location to you privately, Chair, if you feel that would be helpful. But I do feel us as a committee, given that we're discussing the issue of billboards, and we should seek an opinion on that from the Justice Minister in terms of the legalities of CM.
I think it's for the Minister of Infrastructure, and it may be something that you want to highlight to the Minister. I'm conscious that I want to be careful that we don't get into specific constituency work, Justin. But
well, this is about the lead party of government erecting billboards illegally. I think that's an issue for this committee, really.
well, the committee has agreed. The committee has agreed that we'll write to the Minister and ask for reviews, and then we'll see what she comes back with, and then you can take it from there. How about that? Yeah.
Fair enough, Chair. Thank you.
Members agreed? Okay. Right.
Sorry, Chair, it's just for clarification. I mean, I have no problem if somebody wants to raise a query, but it's just if it sits in this committee or not. I mean, we could be asking the Justice Minister for a view on everything, or any minister for that matter. I mean, I don't care in terms of asking for their opinions or views, but I mean, we're here as the Justice Committee to scrutinise the Department of Justice. The billboard stuff came as an update from the Justice Minister, so it fits directly in with this committee. But the member has said, you know, the fact that he wrote to the Infrastructure Minister that it rests with her. So I think going forward, I mean, I've no problem if you want to put the letter in today to the Justice Minister. But I think going forward, it has to pertain to the work of this committee. And if it's another committee, then refer the query to that committee.
I imagine, I don't know what's on the billboard, but I imagine what's on the billboard pertains to some of the work of this committee. But anyway, look, I think the Justice Minister is absolutely not averse to where it's not her remit, saying it's not my remit. So let's see what she says. And then after that, Justin, then it may be an issue that you need to take to the Infrastructure Committee. But we'll write for now and see what the Justice Minister says, and if she says it's anything to do with her, or if she's got a view on it, or if she doesn't choose to express a view, that's a matter for her. But at this stage, the committee has agreed it. All right? Yeah. Okay, let's move on. Agenda item 11 is the forward work programme. Before we get into what's in the meeting pack, I want to remind you that next week's meeting, the Minister's coming, and she has indicated that she has to leave by 3:30. So in order to maximise the time available, it would be helpful if members were available around 1:45 to allow the committee to complete any necessary preparations. Just the way we usually do our kind of round robin, get our questions together and grouped, so that we've got that done and we're ready to start by 2 o'clock. At our meeting on the 13th of February, we identified the following areas for discussion with the Minister. This is just a heads up to kind of to get you in the right headspace. So the issues were the Criminal Bar Association's withdrawal of services and the potential industrial action by the Law Society of Northern Ireland's Immigration Practitioners Group, the terms of reference for the review of the Cresswell-Simpson case, the review of the Policing Board, the Northern Ireland Civil Service Staff Handbook with particular reference to prison officers, and that's pertinent, I think, given the statistics around sickness that are in our pack today, and the Police Ombudsman for Northern Ireland. Now, just around the Police Ombudsman, we need to be careful around the legal case that's pending there, but that doesn't preclude us from asking questions about that office. We just need to be careful about the case. All right. Are there any other issues that members want to highlight? With the Minister, it's helpful to indicate these areas, but it doesn't preclude it doesn't preclude people from raising additional matters. But if there's anything else, it means that the Minister's coming with information she can give us, as opposed to being put on the spot. Is there anything else?
Will there just be a focus on the Justice Bill with her, or not?
No, really, those are the issues, Stephen. She's
yeah.
not coming about the bill.
There'll be not be much talk about the bill specifically.
Unless there's a specific issue
Yeah,
you want
no,
to raise
that's okay,
about the bill. Is there anything pertaining to the bill that you want to raise with her?
No, I'm just thinking ahead, in advance of next week, yeah.
Does anybody have any further issues they want to raise with the Minister? Or?
Will she be coming back on the bills specifically at a point, do you think, or?
Well, we looked at this. I mean, she's due to come, and yes, she will be coming, but the likelihood is she'll be coming at the end, whenever we've kind of taken all our evidence and we've after things to put, because I'm not sure at this stage the value in her coming about that, and whether or not there's more value in dealing with officials until we've got a reason to go to the Minister, because they're the ones kind of through putting this for now. I suspect that there'll be time at the end when we get the Minister in and deal with a number of the issues. Is that how it usually works?
What time does the Minister have to be away?
She has to be about 3:30.
I think we have enough to deal with in half an hour.
Hour and
Without
a
adding
half.
more on to it. Hour and a half? Oh, 3:30, sorry, not half 2. Oh, well.
3:30.
Come on, could you just, what's the titles again there, or what's the headings that you?
Will I get the officials to circulate those?
That'd be useful, and then give us 24 hours if there is anything else.
Come back.
That'll
We could
give
come back
people
to you,
a
is
bit
that
of time to
okay?
just- Yeah. Means we've got a bit of time to get our heads sorted about the types of things we want to ask. Right, is there anything else in correspondence that anybody wants to raise? No? Okay. Then the forward work programme. So there's an updated programme in your pack, page 634. It was agreed at last week's meeting to request oral evidence from departmental officials on the proposed LCM on the crime and policing bill, and that's been scheduled for the 20th of March. We'd also requested oral evidence from officials and from the Human Rights Commission on the revisions to the PACE codes, and that's been scheduled for the 3rd of April. Are you content to proceed with the sessions in the draft ward work programme subject to any changes that we need to make as necessary? Content?
Yep.
Thank you. Agenda item 12 is chairperson's business. At page 643, there's an invitation from the director of the Children's Law Centre to me as chairperson to the Children's Law Centre annual lecture, and that's on Wednesday the 30th of April. Are members content for me to attend that as chairman of the committee?
Content, yeah.
Yeah.
Thank you. Any other business?
Yeah, sure.
Deirdre?
It's just the email, and I know the statement from the finance minister the other day in terms of the transformation bids, and I know there's been 2 obviously successful bids, which we've been emailed today a briefing or a kind of brief update on what they are. One of them was obviously the tagging system that we had raised last week around the GPS element, and then obviously in terms of transformation of the criminal justice system. So I just think, I mean, we could potentially ask the minister this next week, but even if there wasn't an update just giving us more detail on what those bids will entail going forward, I think that would be useful.
And probably the impact of the third one dropping out.
Yeah.
Bear in mind that it's an executive priority, which is bizarre to me. It's bizarre to me that that has dropped out. You know, so the executive highlights that this is what they want to take forward, and the transformation board says, sorry, no. Astonishing.
I suppose on that,
Yeah.
I mean, they did say the other day there's opportunities to bid again, so even to ask, are they going to bring that forward again with whatever kind of queries or suggestions were given by the transformation board? So I think, yeah, an update on all of that would be good. Thank
You
you.
guys have that in then, and yeah. Justin?
Thanks, Chair. Just an issue that's becoming more and more prevalent through my offices, and that is the large number of people coming through my doors distressed as a result of heavy-handed enforcement notices from private parking companies. The Protection of Freedoms Act 2012 is not applicable in the North. In this jurisdiction is the driver of the vehicle who is liable for parking charges, not the registered keeper. We then need clarity on the lawfulness of private parking companies aggressively pursuing the registered keepers of vehicles through solicitors' letters, debt recovery letters, frequent and threatening mailings. What recourse do individuals have when challenging a private parking fine directly with the issuing company if they were not the driver of the vehicle at the time of the infringement? Surely that is a straightforward expungement of the fine. What recourse do individuals have when private companies have passed the fine on to a solicitor or a debt collection agency? Surely if that person was not in charge of the vehicle at the time of the infringement, the debt collection agency must desist. Can we write to the Minister requesting clarification on what the law actually says and what the protections of individuals are? It's totally unfair, the duress and the distress this is bringing to too many people on a daily basis. The behaviour of private parking companies is scandalous and is heaping worry and woe on people unnecessarily. Somebody needs to crack the whip.
Okay. Well, Justin, I think this committee's not going to be the ones to crack the whip. I think the issue with that one is, whilst it's absolutely pertinent and it is a serious issue, I'm not clear that it's for here. I think that your first issue for that is to table written questions to the Minister for Infrastructure and if you choose the Minister for Justice, but we up here think that that is an infrastructure issue. So I think that your first port of call on that is to start tabling written questions to those ministers. And if you're not getting any traction, well then maybe we can consider it, but I think at this stage it's not for us. Is that all right? Can you start in that direction first?
I've already done so. Thank you, Chair.
Well, keep us appraised then of the kind of responses you're getting, but Cathy, having come from Clark in the Infrastructure Committee, is fairly convinced that that's being taken up in that committee.
I don't know that it's been taken up,
Well, it's
Chair,
been
but I would
looked-
imagine that it would
falls
be
under their
parking
remit.
would fall under their remit, and traffic fines and that kind of stuff would more fall under their remit.
Does that kind of give you, and it might be worth maybe having a conversation offline with members of that committee and the chair of that committee, if that helps you? Does that give you a starting point? All right, thank you. Anybody, anything else? No? Right. Date, time, place of next meeting. So the next meeting is going to be next Thursday, which is the 13th of March at 1:45 p.m. in this room. The meeting is adjourned. Thank you, everybody.